speaking with me, Tarun Nangia. This is the part 3 of our series on Justice Sanjeev Khanna that we have titled Justice Sanjeev Khanna as Chief Justice of India, Opportunities and Suggestions. And I have a very interesting panel joining me today. I want to welcome Justice Rajiv Shakdar. He now practices as a senior advocate at the Supreme Court. He joins us on Legally Speaking for the first time. We would like to welcome him on the show and looking forward to see him more often, bringing in his suggestions and inputs on various legal issues. Good to see you, and best wishes for your new innings at the Supreme Court of India as a practicing senior advocate. I want to welcome Senior Advocate Arvind Nair. He's a familiar face of the show, an admin counsel at the Supreme Court of India, the Delhi High Court, the NCLT and the NCLAT. Good to see you and looking forward to some interesting suggestions from you. I have with me Advocate Ruchi Agnihotri joining me on the show. Good to see you, Ruchi, and looking forward to some interesting insights from you as well. At the outset, may I request Justice Rajiv Shakdar that if you could speak for 2 minutes on, so you have served as the Chief Justice of the Himachal Pradesh High Court, and having done that, among today's panelists, you have an idea of how these things are there, how tough it is, how the court system works. Given all that, could you give me your opening comment on Justice Sanjeev Khanna taking over as Chief Justice of India? Over to you.
First of all, thank you very much, Tarun, for having me over and joining this series. I've been watching you doing several of these interviews. So, as far as my comment on Justice Khanna is concerned, I can only say with some amount of experience, having been his colleague at the Delhi High Court, that he's one person who is extremely hardworking. That is something that you would have heard from several people since you cover the court beat virtually, though. The other thing that strikes you about Justice Khanna's personality is his integrity, a man of impeccable integrity. The third thing or the attribute that comes to my mind is about his ability to pore over complex matters to get to the root of the case. So while I did not have an opportunity to work with him on the judicial side, except for a couple of benches, but on the administrative side, we've worked. This was in the High Court, and then, of course, as we go along, I'll speak about that if an opportunity arises. I worked with Justice Khanna as part of a subcommittee set up by NALSA, when Justice Sanjay Krishan Kaul was chairing NALSA. So this was a unique initiative by Justice Kaul, where he had, in fact, set up a subcommittee which was headed by Justice Khanna as the Supreme Court judge, and I had 2 other colleagues with me on the subcommittee, and we had several regional conferences where the subcommittee gave its own views with regard to what initiatives were good or what could be carried forward, etc. So I have seen him work for these last, let's say, before Justice Kaul demitted office, which was in December 2023, a year preceding that date. In each of these initiatives, he came across as a person who believed in getting into the minor details of every initiative. I saw that in his presentations, which were unveiled before the audience. So those are my opening comments about Justice Khanna.
Thank you for your opening comment. We'll now go to Senior Advocate Arvind Nair for his opening comment on Justice Sanjeev Khanna.
Tarun, thank you for having me on the show and part of this esteemed panel. I'm actually hard pressed to add to what Honorable Justice Shagdar has said. He's so much better suited and better qualified, but I completely agree with him. In fact, in addition to the hard work and the eye for detail, I actually had written down a word for myself, and that comes also from what Justice Shagdar said about him. He was extremely meticulous from what we saw of his lordship when he was in the Delhi, when he was a judge of the Delhi High Court. Very meticulous, very hardworking, uh, and also have empathy and compassion for the deserving. And I'll tell you why I say this. And this is, I'm also connecting this with meticulous. I do remember one or two proceedings where there was some, substantial question of law being debated and bitterly contested litigation. But he had an eye, and I'm sure he still does. He has an eye for detail, and he caught some inconsistency with the affidavits. And then those affidavits had to be withdrawn and refiled with a proper and due apology by the deponent, by the party who would filed the affidavits. So, hardworking, integrity, eye for detail, compassionate. Uh, I think we can look at his tenure with very high expectations. And of course, we are also humbled by the fact that you're asking us to comment on where your subject is suggestions for the Supreme Court. Because Supreme Court, I was looking up, is a glorious institution, was established in January 1950. We are reaching 75 years of the establishment of the Supreme Court. It's been around before our time. It's going to be around after us, and it's such an important part of the nation. And so I'm sure the Honorable Chief Justice of India will definitely leave his stamp on this great institution.
Yes, indeed, rightly put. He will leave his stamp, and as I always say, that these days every word that the Chief Justice utters is debated upon, discussed in social media, amongst lawyers, in canteens. Now there's a nice, in a sense, social media. So these days it's not like the times of yore. For next 6 months, everything he utters is going to be watched, debated, and discussed. Rightly, wrongly, that we can have a separate discussion about. I'll go to Advocate Ruchi Agnihotri for her opening comment on Justice Sanjeev Khanna.
Thank you for having me on the show, Tarun. And to be a part of a panel of which Justice Shagdar is a part, it's truly an honor. He was one of my favorite judges. Yes. So I was a
He
pretty
was
young
everybody's
lawyer.
favorite. Just to add to that, Ruchi, he was everybody's favorite.
Well,
And
I said it
remains so.
first.
Remains.
Sorry. I was a young lawyer when Justice Khanna became a judge of the Delhi High Court. And I was at that time in a firm. So what we essentially were doing was corporate commercial litigation. And Justice Khanna was one of the company judges at that time. And that was, I think, one of his first few rosters. And I was one of the lawyers in the firm that was assigned to sort of take the mergers and acquisitions and all of those schemes forward in the previous Companies Act 1956. And my experience with Justice Khanna at that time was extremely pro-government, pretty suspicious of a scheme where he felt maybe the creditors or especially unsecured creditors or anyone would be shortchanged in any manner. It was difficult for us as lawyers because we didn't want suspicious judges asking too many probing questions. But that was my first experience of him as really a judge of the Delhi High Court. Unfortunately, I haven't appeared before him in the Supreme Court. So, but I'm sure he carries that forward. Delhi High Court happens to be one of the best courts in the country, and I think I can say that with some high courts. I can say that with some sense of responsibility. So, and he has been part of that court for almost 14, 15 years. And even now, I hear, I'm doing a lot of work in the Bombay High Court and other places. The kind of filings we have in Delhi High Court, how seamless it is on the administrative side. You see, these are things that Justice Khanna has been naturally a part of. So, the experience that he will bring as CJI, and especially on the administrative side, with his experience on what he has seen in the Delhi High Court, I think will change the game a lot because Delhi High Court is always at least 10 steps ahead of most other courts in the country. As of now, from what feedback I've received from AORs, even including the Supreme Court, in terms of its filings and its, etc. So we'll talk about all of that later, but I think Justice Khanna, with his zeal, to make easy accessibility to justice, and his natural inclination to sort of deliver substantial justice, will make a difference.
Thank you for your opening comment. Now we'll go to the substantive part where we make suggestions. And I'll go to Justice Radhish Akhtar. In the earlier shows, Dr. Abhishek Manu Singhvi gave some suggestions on how cases should be heard, what categories of cases. Then we had Advocate Mahesh Agarwal and Advocate Ruby Singh Ahuja from Karanjawala and Company making some suggestions on some physical aspects, also listing registry. So if I may ask you, even if you could give suggestions from your end on varied aspects, right, from physical infrastructure to registry to listing of cases, and anything else that you may want to suggest with related to online hearings, over to you.
Yeah, frankly, Tarun, it's actually taking gold to Newcastle, in the sense that Justice Khanna has been a senior judge in the Delhi High Court, where he was involved in a number of initiatives on the administrative side. Of course, since he was elevated directly to the Supreme Court, he did not have the opportunity to preside as a Chief Justice of a High Court. And that said, that can't be a handicap, as there were several initiatives which senior judges or senior leadership in every High Court is mandated to carry out. Now, as far as suggestions are concerned, I'm sure they are pouring at the time. Each CJI has several counselors, wanted and unwanted. Justice Khanna would have to choose what he wants to, and he would, I'm sure, given his sagacity, listen to all suggestions and do what he thinks is right. Why I say so is Justice Khanna ultimately is his own man. Often people say he's like a person who wears a velvet glove, iron hand in a velvet glove. So, that said, if I can endeavor to make some suggestions, in my view, although I had a short stint as a Chief Justice of the Himachal Pradesh High Court, I can tell you each day counts. I had several challenges when I went there as a Chief Justice. So the best way to solve these challenges is to have a conversation with the bar and conversation with your colleagues. It is important to have collegiality both amongst the judges and collegiality with the bar. You cannot function unless you establish that rapport with both your colleagues and the members of the bar. So, I would tell you straight away, although my foray in the Supreme Court has been brief, I rejoined practice only recently, and like some of my colleagues told me that this is your third innings. I was a senior advocate before I was invited to the bench, and after a fairly long stint of 16 and a half years plus, I've gone back. But the inputs that I've got are briefly the following. One is that perhaps, and this is something that the court could consider, is after you've had inputs from all sections, which is the bar, bench, etc., you could also devise a strategy where you pick up matters on sectoral basis. I heard other speakers on your show. There was a lot of emphasis on infrastructure matters, correct? Uh, because when there is a logjam there, it, in a sense, uh, uh, sort of damages in a long term, on a long term basis, the economy. But that said, I also believe there are matters with soul, as I call them, as in SOUL and not SOLE. And these are matters which concern individuals. So, whether it is senior citizens, women, children, disabled persons, they sometimes don't receive the kind of attention that they should. Ours is a people's court. And given the demographics of our country, we need to look at these sectors as well. So, uh, let's start with the disability sector. Uh, in Delhi High Court, I was part of the Delhi High Court Legal Services Committee. I was, in fact, chairing it. So when I had discussions with people who were, suffering from one disability or the other, one of the things that came through is that, while you may address the infrastructural issues that they face in courts, which is both physical and virtual, because you need to navigate websites also. Uh, was that at the end of the day, lawyers who are differently able, they need work, correct? Even to prove to yourself that you don't have it in you, whether it is a person suffering from disability or a person who's able, uh, he needs an opportunity in court. They need money. More often than not, they come from a strata of society which doesn't offer much. So one of the initiatives that we took, I don't know whether Chief Justice Khanna would like to consider, is that you need to put them on these legal aid panels where they get work assigned and they earn some money. There's a gentleman in the Delhi High Court who's completely wheelchair borne, and he has a speech impairment, but he has an excellent mind. So we had to devise a methodology as to what is the kind of work we could give. We gave him an advisory role vis-a-vis litigants who came to court. Believe you me, Tarun, he was so thrilled that not only was he earning some amount of money, which was a modest amount, but he was actually able to put his knowledge to use as a lawyer. And then to mark them matters where they come to court. So this is as far as lawyers are concerned. I'm not getting into great detail because there are other speakers in the panel as to what are the other aspects you could attend to. You need screen readers, you need audio, facilities, you need sign language interpreters. And therefore, what you need to do for this sector is the cause list should indicate that X or Y matter on the day's cost list before a bench is a matter dealing with differently abled person. It could be a litigant, it could be a lawyer. The judge should be made aware of, and if the registry could do that in advance, the judge or the bench could also be made aware of the fact of the kind of disability he suffers from. Because suppose he has a hearing impairment, someone should actually make an attempt to get him a sign language interpreter on that date. The judge should be aware that this is the problem with the person, and therefore he also, in a sense, mentally prepares himself to navigate that case. Not that when he appears in court, he shuffles, he moves, then we make some clucking sounds, make way for him, so these people are not looking for empathy, they are looking for opportunity. Now, this is something that needs to be addressed. They need a equal opportunity policy. Section 21 of the RPWD Act says that there should be an equal opportunity policy, which is for the staff who are differently able. We have several people who are differently abled, clerks, interns, lawyers, and litigants. So this is one sector. Women and children is another sector. And of course, senior citizens. Now, every court has this system of having cause lists for saying senior citizen cases. My experience is they don't get the kind of attention that they should. Should we allocate time? Should we allocate days? We need to work on this. I mean, money for the economy is good, but as I said, we need to address matters which touch people. So, and the other suggestion that I have, which is something that came to my mind very recently when I was practicing, that the Supreme Court has now developed a practice of sequencing matters. Correct? You have a cause list where you have items 1 to 40, and then you also have a sequence in which a particular bench will take the matter. Now, a lot of lawyers told me that if we would know the sequence that the court is going to follow, which is not necessarily what is the seriatim number in the cause list, it would help us to arrange matters. So, should you do it a day in advance or at least by 9 o'clock that date, so that lawyers know, do I go before court number 1 first, or do I go to another court or another bench? So, we can talk about it more if time permits, but these are some of the things that I got to know immediately upon re-entering the court.
Point well taken. Thank you for going into the minutiae, and maybe the part one of your answer, which you said on disabled people being given opportunity. Maybe this makes our world class or our developed world courts, maybe, where these things are a given. Are they so? You may be able to better tell us. I assume they may be a given, this kind of infrastructure. I'll go to Senior Advocate Arvind Nair for his suggestions on what could be done, and including the registry, including the physical infrastructure, including any other thing that he may want to share. Over to you, Mr. Nair.
Tarun, I must confess, I had the benefit of seeing the show where you had my esteemed colleagues Ruby Singh Ahuja and Mahesh Agarwal as guests. And I'm going to borrow from some of the stuff, some of the suggestions that they made. In fact, Ruby said something very, very pertinent. She said something about for the benefit of the younger bar, because she was talking about how younger counsels mostly now you have moved to digital files. They don't have the entire, infrastructure of court clerks and, assistants and all of everybody running behind them. So they all have their files on their iPads, and most of them are very comfortable. In fact, we learn from some of them. They also do their hearings very seamlessly by virtual mode. She said something about liquid text, etc. Now, I have one more suggestion, just as a continuation of that. When lawyers who are waiting, and obviously, when you have a hearing listed or multiple hearings listed before the Honorable Supreme Court, there is always going to be some element of waiting. Because as Justice Shakdar also said, there is sequencing. Every bench has its own way of hearing matters. Sometimes there are hearings which can go on for longer than you expect. Sometimes the board can also collapse. Both things happen. What we need is, we need to have, and it's a common sight that you will see people, it's an old heritage building. It's constructed in a certain way, and I'm sure there are security considerations also. But we often see people running from one spot to another to get better network. Now, the entire exercise of digitization, if we have to optimally use it, if we actually have to do away with paper, and if we actually have to have this very efficient virtual mode in operation, whether it's for somebody to complete their drafts, for somebody to watch another court in the Supreme Court or outside the Supreme Court, whether it's for somebody to manage their other appearances, we need to have, a steady kind of network reach at all spots, at least the main building where most of the courts are located. All of those corridors, you are of course familiar with the layout of the Supreme Court. So, lawyers should not have to run from one spot to another, that this location has better network or that location has better network. I think that is something that should be looked at. And I'm sure the Honorable Chief Justice of India, with his eye for detail, will look into it so that, not everybody congregates in that 100-meter area where the network is supposed to be better than the other locations. I think if that is done, if we can have uniform network, I mean, I'm not going to extend it to say inside the courtrooms, because nobody is going to log in and try and do another hearing or watch another court from inside the courtroom. But certainly from the corridors, waiting areas, the Supreme Court has a huge footfall. It doesn't matter how many waiting areas you build, there are always going to be, with the kind of population density we have, there are always going to be people, lawyers, advocates on record, lawyers who come from out of station, litigants, parties who want to argue their cases in person, whether they are senior citizens. There are various categories: home buyers, those who cannot afford uh, uh, councils and senior councils, who want and who also feel that they are better equipped to address their disputes and their issues on their own. So there is always going to be a crowd. I think if we can have this improvement in the reach of the network, better internet, better Wi-Fi, better network all over the place, I think we are going to be able to optimize our system, and that can only have benefits. To borrow from what Justice Shakdar said about having more facilities for disabled people, maybe we could have consultation rooms where somebody who may not have the access to get to a particular court, or may to be able to sprint from court 1 to court 12, he may be able to sit in one location and with a good network be able to attend one hearing after the other. So that's one part of it. The other suggestion that I have is, again, it's connected to the footfall. I think the canteen cafeteria space that we have, and I'm saying this from the perspective that there is often waiting of a few hours involved in the main building. We now do have a cafeteria in the chamber blocks. Also, we have a cafeteria as you step out of the main building. I'm restricting my suggestion to the main building. The canteen and the cafeteria that we have in the main building at the moment does not have enough capacity to ensure that everybody who wants to sit there and have lunch or have a cup of coffee, or even just take a break, gather their thoughts between hearings. I think we need a little more space. As I said, there are restrictions. It's an old heritage building. You can only carry out extension, addition, or alteration in a particular manner. But I'm sure the Honorable Chief Justice of India will look into this, because this is something that needs to be done. So Wi-Fi network is one, the cafeteria facilities is another, and so the about the registry you asked me, again, to borrow from what my esteemed colleague Mr. Mahesh Agarwal said, and to connect it with what Justice Shakdar said, the Honorable Delhi High Court has a very seamless way of listing cases, and the Honorable Chief Justice of India has had a long, distinguished tenure in the Delhi High Court, and I'm sure some of those features, the Delhi High Court perhaps is one of the few courts where if you file a petition and the defects are cured by noon, it automatically gets listed the next day. Now, this is something unique to the Delhi High Court. I'm sure some of these features will be incorporated by the Honorable Chief Justice of India in the working of the registry. But then every court has its own challenges, the number of filings, perhaps, the way it's done, the people who come from all over the country. So there are challenges which perhaps none of us are aware of. So I'm sure those challenges will be looked at in the usual meticulous way by the Honorable Chief Justice of India.
Look forward, maybe some of these things may be implemented. On a lighter note, Justice Khanna would like to, maybe summon one of those telecom service providers to see at least the Supreme Court has enough connectivity. But maybe I think the administration would look into it. But a very nice suggestion there, because so many of you spend so many hours every day, and it's indeed work. I'll go to Advocate Ruchi Agni for her suggestions.
Yes, thank you, Tarun. A lot of things may be a little repetitive, but I hope you sort of bear with me. To start off, there's some data points. I'm not sure whether this is correct. It's been picked up from the public domain, so please don't hold me to it. I believe as of now, there are about 82,000 plus cases that are pending in total before the Supreme Court, of which about 64,000 plus are civil matters and 18,000 plus are about criminal matters. 1/3 of these total pendencies are just less than a year old. Now, the main point is 3 matters again, this is public domain, please. So I really don't know because I haven't checked this with the registry. 3 matters apparently need 9 judge bench to hear it. 19 apparently require 5 judge bench to hear them. And there are about 152 matters that require 3 judge benches. Now, a bench of 5 plus judges is considered a constitution bench. And while Justice Chandrachud did have many constitution bench matters, it is entirely the discretion of the Chief Justice of India. There are no guidelines because he's the master of the roster, right? And he's considered first among equals in the administrative side. In the judicial side, a Chief Justice is the same as his brother or sister judges. But on the administrative side, the Chief Justice of India is the first among equals. So he has very, sweeping discretionary powers on how he can allocate cases and how he can set up rosters or have constitution benches. Again, in my discussions with a few AORs, what has come up is that it would be better if there are more constitution benches, not just limited to the Chief Justice of India being a part of each constitution bench, because at least those 20 plus odd matters which are constitution bench matters can also have efficacious hearing. The other thing that I heard from a lot of AORs, etc., was that the old system of seeking an adjournment by way of email was a better system because it was more efficient and everyone at least had a sense that this matter would not go on because an email or a letter had been circulated. So that again, the question is if there are 82,000 odd cases pending, the first thing is to reduce pendency. And and as Justice Shagdar said, he's his own man. So, and I'm sure he wouldn't want to look at precedent and he would set up his own precedents on how he is going to be viewed as the master of roster. 6 months is good enough to sort of set up a new system and for people to either like it or adapt to it or not. So the first suggestion is probably look into setting up more constitution benches to finish that pendency, because those are important matters. There are very big important matters that are pending. There's that Google antitrust matter. There is a Sabarimala larger reference that is pending. There is a criminalization of marital rape matter, Justice Shagdar, which is pending. His dissenting judgment is one of the things under review there. So there are many important matters that are pending before Justice Khanna. Before the Supreme Court of India, and probably having a few more constitution benches wouldn't hurt. One, having the old system of adjournment is a better thing, as is what I have heard. The third thing that I have heard is that it would be good to have more subject matter benches. As of now, if I believe correctly, there are only about 2 subject matter benches, and that comes from, I think, what Justice Shagdar was mentioning about, I think the previous speakers on your series have actually mentioned something like that. So that's another thing that I had as feedback, that, to allocate subject matters. For example, we already have that in Delhi High Court. It would probably be a good idea. And Justice Khanna has come from the Delhi High Court, so these are very normal, natural things. On the digitization part, to add to what Arvind has mentioned, one of the suggestions was get the registrar of the Supreme Court to work with the registrar of the Delhi High Court and get some sort of training process in place, because apparently while everything is e-filed, it is also physically checked. Whereas in Delhi High Court, it is not physically checked at all. It is a seamless e-filing. And therefore, things are, as much as they're changing, they're pretty much remaining the same, is what I have heard. Also, the young lawyers or lawyers that who don't have huge infrastructure availability. Delhi High Court apparently has a system of assisting them in scanning and photocopying, etc. So something like that, if the registry of the Supreme Court could also have, it would help the lawyers who are not that financially, enabled to do everything in their own chambers or in their own offices. And another pain point that I heard was that while everything is being e-filed, there is no continuous page numbering. So there is a lot of time wastage during the hearing because everyone is referring to a different page and the bench is referring to a completely different page. So if the registry could have one, for example, in arbitrations, we have what is called a hearing bundle. After everything has been filed and before the hearing, the entire record is refiled and continuously numbered so that, there is only one page number that is being referred to at any given point of time. Rather than that will also make sure that the matter is heard that much faster, right? The idea is, of course, to reduce the pendency. Also what I heard was that in batch matters or in connected matters, only the AOR who has filed a particular matter gets the entire record available, but they don't get the batch, the other batch petitions or the other batch matters records. So if they have, everyone has everyone's, because it's a batch matter, it's going to be heard together, right? Then also it makes that hearing that much more seamless and that much more efficient. So on the e-filing and the digitization point, that's what I heard. The other thing, of course, Arvind has already covered, which is that there should be more charging points and better Wi-Fi connectivity. So these are a few things. Yeah, the other thing that I heard was non-miscellaneous days. So apparently on Tuesdays, Wednesdays, and Thursdays, there is that after notice matters should also be taken up. Because as of now, they're not being taken up, and there is a huge backlog that is getting built up because of that. Yeah, I think these are the few things that I learned because I don't file in the Supreme Court.
But thank you so much for, this was a nice, good list of suggestions there. Now we move on to, in a sense, the final comments where we wish Justice Sanjeev Khanna for this tenure. And of course, this is a privilege. Only a few get to become the Chief Justice of India. Many become judges. But in addition to everything, you need a lot of luck to be where he is. So in the end, final round of suggestions with your good wishes, starting from Justice Shankar.
First of all, Tarun, brave men make their own luck. Luck only assists you. So if you have the intention, which I have no doubt Justice Khanna has, luck will follow him, not the other way around. So while I wish him the very best, as I started by saying, navigating both the judicial side and the administrative side is not easy. We have some 3,240 court complexes. So often what happens is, and I think Justice Khanna is very conscious about this, that most of our conversation is Delhi-centric. You have to step out of Delhi to know what other courts have or they do not have. And I can only come back to my own experience that Himachal Pradesh High Court is a mid-sized court. It's not a small court, it's not a large court. But did it have the requisite IT infrastructure? It didn't have. In fact, the joke was when I wanted to do a VC hearing, the machine used to be carried on literally a trolley to my court, and then we would view it. Now, this is not a comment on the court, but the point is somewhere we've missed the bus. So Justice Khanna has at his command some 9,000 crores that the government of India has given, correct? We need to do a realistic IT audit of every high court to begin with. You can go down to if you go down to the district courts, it's perhaps worse, and see where we are and bring everyone at the same level, because conference after conference, I have heard lots of my colleagues when I was a judge in the High Court that why does every court have to invent a wheel? Now Delhi has been lucky. We seated in IT much earlier. I was lucky. I got the baton from some very seasoned people like Justice Lokur, Justice Badar, Justice Muralidhar, and therefore it continues. So in Delhi, lawyers are lucky, correct? But when they travel outside, they realize what's the difference between what you have in Delhi and what you have in other courts. Now, today with the virtual world, you want to be in every court, and every lawyer wants to be in your court, and you want to be in other courts. I don't have to go far when you compare courts like Bombay, Madras, Calcutta. They all want to come up to a particular level. So, first suggestion to Justice, suggestion, call it whatever, is beyond my pay grade in that sense, if I can use that, is that please do an IT audit, please do a disability audit, so that you know, because you need to know what the problem is before you can address a problem. So that's my suggestions, 2 bits.
Thank you for giving the suggestions and good wishes to Justice Khanna. Now over to Senior Advocate Arvind Nair for your good wishes and final round of suggestions to Justice Khanna.
As I said, Tarun, I'm sure the Honorable Chief Justice of India will leave his distinct stamp on this highest office. There isn't much left for me to comment on. I think Justice Shagdar is really, in his usual erudite way, covered almost everything there was to say. I am just going to borrow again from what Ruby said. I think, and this is a wish, and I'm sure this will come to pass. I'm sure, I just hope that and I am not being regressive here when I say this, but I hope, and I'm all for free speech, but I hope that we go back a little to the slightly older times where the Honorable Supreme, there is really no controversy attached, in the sense that every observation is not commented upon, every observation or exchange is not debated on in a sort of a negative perspective. So that's a hope, and I'm sure it will come to pass. Like I said, glorious institution, completing 75 years, has been around before I started practice, will be around after we've hung up our boots. So that's one. The only other thing inside the courtrooms, and again, as I said, I say this with a lot of humility, because I'm not sure I'm qualified to say this, but because every bench has their own way of conducting matters. But again, coming from personal experience, a very large number of matters that are heard before the Honorable Supreme Court are batch matters. Now, what happens is, obviously, there is, uh, except for a time when, unfortunately, perhaps during the pandemic, when everybody had to shift to virtual mode, counsels and lawyers do prefer to be there physically. So in these batch matters, what happens is there is a huge crowd and a huge rush. And forget the lawyers and the counsels, I think it becomes very difficult for the honorable judges to sort of navigate through a batch, which sometimes takes away from efficiency. And because of this, because of everybody trying to over each other, sometimes hearings get deferred, matters get adjourned. I think a sort of a sequence, and it's already begun, this practice of appointment of nodal counsels and counsels who will coordinate the hearings, a list to be given, how much time will be given to each counsel, in which sequence a batch has to be heard. This process has already begun, and I'm sure the Honorable Chief Justice of India will only just perfect it and make it more efficient. That's all I have to say.
Thank you for your closing comment and your wishes for Justice Khanna. Over to Advocate Ruchi Agnihotri for her wishes and comments, if any.
Well, good wishes are always there, and there is a lot of hope that, as Arvind mentioned, it's an evolving institution. So there will be some evolution and there will be steps forward. So that's the hope. The good wishes are always there. And he's been a judge for many, 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 many years. I think he's going to complete 20 years as a judge. So no suggestions for him. He knows how to demit his judicial office. Just on the administrative office, as Justice Shagdar said, this is literally his first stint as being the administrative head of the highest judicial institution in this country. So therefore, we are just bringing, as stakeholders, little suggestions that we have, and I'm sure they will be all taken into account. And there should be changes. It's an evolving institution. I mean, we've all seen it change over the years, yet remain the same. And I agree with Arvind on the batch matters issue, not only sequencing, etc. The other feedback that I had was, if one could be told what matters will be taken up and what not taken up, that would automatically reduce the number of people sitting inside a courtroom waiting for their matters. But these are small things, and but these small things actually do lead to a lot of efficiency and efficacy in how. So procedure is the handmaiden of justice and not its mistress. But I don't think anyone can function without a very good handmaiden. So I think, yeah, procedure should really be fine-tuned.
Thank you for your closing. Anything else you wanted to say? No, that's about
No,
it.
thank you.
In fact, as you were saying that he's served as judge for 20 years, my mind went back to the year 24th October 1994. That is 30 years and 1 month ago. That is the day when Justice Venkatachalaya retired. He's still around. It's been 30 years ago. The world has changed. He's there. He's talking. He's part of seminars. He's commented upon. His judgments are discussed. So life is long. 30 years ago, somebody retires. He's still working. He's in public life, and you are discussed. So this tenure, of course, will be, in a sense, is much. I mean, the most glare ever that is on a person is when he is occupying such positions. So that is why he will be watched very closely, reported on, discussed, debated, not now also, much after he retires, because these things you carry, you leave your imprints on time. But we like to wish him well. And also, it'll be nice if we could have some more judges in the Delhi High Court. It's been long that, we will 37 out of 65. I think we need more judges. I think being from Delhi, I think that will also be considered. But thank you, Justice Sagdar, Senior Advocate Arvind Nair, Advocate Ruchi Agnihotri. You found time for Justice Khanna. You all came together. You all gave your valuable comments. I really appreciate that. Thank you so very much.
Thank you, Tarun. Thank you for having us.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.